Good afternoon.
Long day. Good afternoon, Chairman Hernandez and members. I'm pleased to present to you Senate Bill 1283, which authorizes cities and counties to adopt by ordinance health and safety standards and enforcement mechanisms for structured sober living homes. Unlicensed and unregulated sober living homes have popped up around our state. Unfortunately, without adequate oversight, these homes may undermine instead of foster an environment where recovering addicts can seek to maintain their recovery. This legislation will provide clarity to cities and counties who are adopting ordinances that create oversight for structured sober living homes. Under this bill, local health and safety standards for structured sober living homes would include, but need not be limited to, mandatory registration requirements, in-home supervision requirements, and the establishment and maintenance of an operation plan that addresses maintenance of the property and noise abatement. The registration requirements would include the name and address of the structured living home, the property owner's name, address, and contact telephone number, and if the property is leased, a copy of the lease. By providing clarity to cities and counties with regard to adopting health and safety standards, this measure will benefit recovering addicts, their families, as well as the communities and neighborhoods excuse me, where sober living homes are located. To address some of the comments from the Health Committee analysis, I'd like to thank the committee certainly for the analysis and just briefly address a few of the policy comments, because I'd be more than happy to work with the committee on amendments that address the concerns in the analysis. First, this bill is explicit that an ordinance must comply with state and federal housing laws and the Federal Americans with Disabilities Act, and it's important to note that what has happened in some of the cities by not following that strict regulation, strict process in their regulation, they have in fact violated, or at least through courts have violated meeting those standards. Second, the bill not only states that a structured sober living home is not subject to state licensure and regulation as an alcoholism or drug abuse recovery or treatment facility, it further stipulates that it does not establish a new category of state licensed facility or otherwise authorize a structured sober living home, excuse me, to provide any service for which a license is required by state law. And again, I'd be happy to work with the committee to provide further clarification that this bill does not apply to licensable services. Finally, the bill does not provide for any responsibility for DHCS to oversee the structured sober living homes. With that, I'd like to turn it over to witnesses who are here to support the legislation.
Thank you. Please proceed. Name and position, please.
Mr. Chairman, members, Dan Keurig on behalf of the League of California Cities in support of the bill. The analysis does really do an excellent job of sort of tracking not only the policy issues involved in this matter, but also a lot of the history. As you can see, the legislators, bipartisan basis, have tried different approaches to try to deal with this issue, and obviously it still hasn't been adequately addressed because their bills continue to come forward. The challenge is, and as if you look at some of the actual provisions of the bill on page 3, what are we talking about? A contact person for the facility, sort of who to talk to if there's a problem. Some really basic things that local communities would like to at least have, so that when there are issues with the facility, that is in some ways operating sort of as part of the social service network, that if the facility isn't being properly managed, if there's issues with the facility, that there's a way to begin to try to address it. Now, some legislators, and I know former Senator Wiggins was able to get a bill to the governor to have more areas of licensing for these facilities, and we would support that. I believe Senator Cornett, even prior to that, had a similar bill. And so we do support the author's effort to try to find some way to have a little more control over these facilities and accountability for the facilities, because especially when you have a facility that isn't operating correctly, when the community is seeing outward signs of maybe neglect in terms of the facility or noise or police calls or other things, it's probably not going too well for the folks inside the facility either. So we hope that there's maybe common ground to try to find a way to better regulate these facilities for both the residents as well as the community. For those reasons, we support the bill.
Jonathan Clay on behalf of the City of Encinitas, also here in support. This has been an important issue to the city for many, many years as we've struggled to try and deal with these types of facilities in our communities. And this bill, by simply just giving us the ability to have simple information such as the location of the facilities, points of contact, at least helps us in dealing with our own citizens if issues arise, complaints come in. So we think this is a very good step forward to trying to deal with this. Thank you.
Mr. Chairman and committee members, Skip Dahm on behalf of the Community Associations Institute, which is an organization of homeowners associations in California, of which there are 50,000 neighborhoods. This point of contact is very important, the accountability, the accessibility to communicate with the right persons if there is an incident in the neighborhood. Some of these facilities are established without our knowing. More than half of the community associations don't have an on-staff manager or a employed manager, or perhaps not even a portfolio management firm. So it's up to the other neighbors in the community to be responsible for themselves, and should events arise that they need some help, the local criteria that this bill would seek to create would greatly help not only the homeowners association, but the residents of the facility itself and their staff. Thank you.
Mr. Chair, members of the committee, Mark Aprea, I'm here on behalf of the city of San Clemente, and we would urge your aye vote. We believe that the current circumstances that are provided in law are inadequate, in that local agencies now are torn between serving the residents who are in that facility, the residents that surround the facility, and have no guidance as to what would be an appropriate regulation of those facilities locally. And absent statutory authority, the matter ends up in litigation, which serves no purpose. There are legitimate concerns both from the residents, the owners of these facilities, the neighbors, and the city council, and we believe that this measure would help move that forward and provide that kind of guidance.
Thank you. Any more support? Opposition? Good afternoon.
Thank you, Mr. Chair. I'm Mike Carroll with the Western Center on Law and Poverty, and it's with some reluctance that we have to oppose Senator Bates' bill. She's someone who we've worked on many measures, and we have a lot of respect for her work. And but today, this bill, we feel, is not one that's should be supported by this committee. We would ask you to cast a no vote on it, or not to vote in favor of it. And here are the reasons why. People who are struggling with drug and alcohol addictions have been found by the courts to be a suspect class. Any ordinances or measures that attempt to limit their ability to live in our communities are given strict scrutiny by courts. And that's because these are folks with special needs, and unfortunately some people have a stereotype about these people, as there are with other folks in our community, that limit their opportunities to live in our community and be part of our community. That's one very deep concern we have. More importantly, federal and state fair housing laws have long prohibited any restrictions on individuals of 6 and under being able to live together in a single-family residence. And that restriction means that if we are going to impose a standard, an ordinance, local ordinance, regulation, county regulation or ordinance, it has to be imposed on everyone in our communities, not selectively targeting and choosing one type of housing or one group of individuals for that kind of regulation. And unfortunately, SB 1283 does do that. It defines and creates a new category called structured sober living homes, and it then subjects them to local regulation and ordinances. Health and safety standards, enforcement mechanisms require a requirement of registration that would be adopted by an ordinance that is not defined in the bill. So all of that is sort of facially flies in the face of fair housing law and the requirement that any restrictions that get placed on single-family homes of 6 and under have to be applied to all of us. And the real concern at the end of the day is that even those who are well-intended, and I believe Senator Bates is well-intended on this, that there are many communities over the last 20 years which, with this law or without these laws, adopt measures trying to restrict placement of various types of facilities within communities. And so we feel that a passage of this bill sort of invites those communities to do that and invites the neighbors who are the opponents of these projects to come forward strongly. And it makes it very difficult for local government officials to be able to cite these places. We have a crying need for these facilities of all types in our state. We should not be erecting barriers that make it harder to cite them. Thank you very much.
Mr. Chair, members of the committee, Robert Harris on behalf of the California Society of Addiction Medicine, the 400 medical doctors in California who specialize in the treatment of substance abuses. The thing that's happening right now is with the adoption of the ACA and parity for substance abuse and mental health issues, that the federal government's now moving forward with making sure that more treatment happens. And additionally, California just did the 1115 waiver to expand the kinds of substance abuse treatments that's allowed for Medi-Cal patients. All of this cries out for unfortunately, more treatment facilities. Because if you don't have the treatment facilities, what good does it do to say that someone has the right to treatment? So this bill, on the other hand, would limit the opportunities for people to get into treatment by narrowing the amount of facilities you could have. So we just think it's going in the wrong direction, you know, and it's really important to understand that, sure, people as neighbors don't like or resist having these kinds of treatment facilities near them in their neighborhood. But it's just as important to understand that actually they're worse off having the people be drug addicts next door to them, and they don't know it. So the visceral reaction that people have to these kind of facilities doesn't match the reality, right? It only matches people's fears. And so we would ask you to vote no for this, and simply because we need more treatment facilities, not less. You don't need to limit how many can exist. We need to figure out how to have more. So with that, we would respectfully ask for your no vote.
Anyone else in support, in opposition, I'm sorry.
Hello. Hi. Sherry Daly with the California Consortium of Addiction Programs and Professionals, representing thousands of addiction counselors throughout California and hundreds of programs as well, urging your no vote on this bill.
Mr. Chair, members, Steve Carlson for Promises Treatment Centers, owners and operators of several drug and alcohol treatment centers. What the unfortunate impact of a bill like this is going to push centers into out of the places that kind of don't want them there into other places. And thinking spreading these facilities out into all communities of all levels is the appropriate way to go, and we unfortunately have to oppose the bill.
Craig Brown on behalf of Cliffside Malibu, and also speaking for Sherry McHugh on for One Method, she's stuck in another hearing. This bill will simply allow jurisdiction to adopt regulations that allegedly weave between state housing law, federal housing law, and the ADA, and it will be on the burden of the facility to sue the jurisdiction to get around those. That's a one-sided fight. People would simply have to close shop in such cases. We urge your no vote.
Okay, any questions? Yeah, Senator Roth, actually, Senator Walk, raise your hand first, and then Senator Roth.
Thank you, Mr. Chair. Senator, I've served on the City Council, as you know, as you have. When I'm looking at the bill, in particular page 3, and the information that from 1 through 3 that you seek to mandate, why is this not part of the business license that this home would probably have to obtain in a city, unless times have changed? Maybe Western Center can speak to this. I mean, the name and address of the living home, property owner's name and address, copy of the lease, I mean, the property, I mean, doesn't that come with the territory of opening a group home in, what's changed from when
I haven't sat on a city council. I wouldn't know either, Madam.
Well, okay.
Maybe one of our other witnesses.
So I'm trying to figure out what is it, why?
Senator Dan Carrick from the League of California Cities, it's my understanding that we can't require a business license of these facilities for the reasons that Mr. Harold pointed out, that the arguments about the Federal Fair Housing Act and other things. So these facilities are basically unregulated, and therefore you've had, the list of bills that's in the analysis of different ways to try to address the problem, but it should be addressed.
It's important to understand that these are not facilities or programs. These are people's homes. So to require any residential home to register with an entity is where the rub is when you look at the fair housing law and what the Ninth Circuit has ruled on in these cases. So it's not possible to impose a mandate on a residential setting.
But these are businesses.
Senator Wolk, that has come up a number of times. Many CCNRs do prohibit businesses being run from the home, but they're not necessarily enforced by the city. Those are individual, but the law requires if it's applied to one, it's applied to all. So you have many home-operated businesses, as we know, especially with the technology that goes on and allows us to do that from our homes. So that's something the cities have avoided because it would affect everyone. But these are quite a bit different than a homeowner who has a business in his home. So, but it is something that it would rise to litigation that they are being treated differently than the rest of the entire city if there's no business license for this type required. And again, the purpose of my bill is to try to provide a framework where a city council would approach a discussion like that if they wanted to go. That's not health and safety. That's basically the requirement that some cities have in terms of home-run businesses, the parking issues. This just sets out a path for them to follow, always staying within the parameters of the federal and state laws that currently exist regarding the manner in which these people may congregate in a group home. I always like to focus on the fact to what the witness for the Western States Law and Poverty regarding protected class. this bill is about that protected class. What we find is the people in these homes, because there's no immediate connection to the city and an oversight that we have generally in our cities for public health and safety, we believe, and I know in my own neighborhood, there's one right around the corner from me, there were serious, what I call abridgments of the treatment plans that were supposed to be undertaken at a satellite facility for these individuals in that home, to the point that one of the residents escaped. That was her comment to my neighbor, who found her on the street crying that she'd been locked out of the home. Many things had gone wrong within it, and we didn't even know for many months that this home was there. So they're not performing in the manner that I believe is protecting the protected class and getting them on the road to recovery. This presented itself as an opportunity because it has been instituted it has made it through both the Senate Health Committee and the Senate in the state of Arizona, where they've had a significant problem in one of their cities, and a county within an area within that city where you had 300 homes in one particular area. So the concentration of them certainly doesn't support what is intended with one of the recovery homes. It's an institutionalization practically of one community where you have 300 homes operating, and you don't have that community character, the neighborhood support, a lot of instances of mistreatment in the home. So if you have some opportunity for local government, who's closest to the issue, to draft a process that they can have some oversight, and I think registration is the easiest one, so that you know that where they are, and that puts them on notice that they are registered, and that there will be, they need to abide by local ordinances, which include noise abatement, parking issues, all of that. But now that goes, until there's major complaints and major problems, then the city is almost reactive, and then they go the other way, which can become discriminatory, and we know that that has happened in a few cities. I will also share with you the city of Costa Mesa was successful in the imposition of some ordinances that were upheld by the court, specifically on the issue of community character, where we had created a couple of areas within their city that were almost institutionalized by the number that were on individual blocks, and that was not in the best interest of the protected class and their recovery. And also they were so close together that they were basically overtaking the neighborhood and changing the character of a neighborhood. So on those 2 points, the city was successful in the way they implemented an ordinance to address those specific things. So again, this is a pathway for them to have the opportunity to explore if they're registered, and then they understand the rules they have to abide by. The protected class will be protected. They'll be on the road to recovery, we hope, and that's the way this thing should operate if we're really intent on helping people on a path to recovery. But without any oversight, and there's currently none, we don't have that path. And the analysis actually says, which I thought it really caught my eye when it said, does this solve the problem with sober living homes? The analysis actually, recognizes that we have a problem. And the problem impacts, if not the neighborhood as greatly as it does the people who are in these homes for the sole purpose of getting clean and being on the path to recovery. And that is certainly my major concern in trying to help provide some sort of, concept and that will assist cities in doing the right thing.
So let me just make a couple comments and see if this kind of helps clarify the policy. And then obviously you decide whether or not you want to move forward with that. So these facilities, my understanding is that it's a home where a few people want to come and just live together, but not necessarily are being given instructions or being taught about, getting off their addiction, but they just want to be around other individuals that have the similar problem and want to live there. So I can understand the argument about the fair housing law, that if you're going to do that, that's not appropriate because that's their home, their place of residence. But let's talk about the bill and the policy of the bill and why I'm willing to support it because what she's asking is that if you live in this, it specifically says here, for example, section 11759.70, that this facility has to provide structural activities that are directed primarily towards the recovery of substance use disorders in the supervised settings of a group or of unrelated adults, et cetera. And then the other section says you have to include a discharge plan. So now that tells me you're going to institute treatment there. Well, if that's the case, then yes, it should be licensed. It's not a place where somebody just lives. And yes, I agree, then it's going to have more facilities. So the question for the committee is, do you want to create policy to tell these people who just want to live there that now you've got to be a facility with a treatment plan? So if you're going to be doing a treatment plan, yes, there should be licensing by the state of California. So that's where I fell on the policy. But it doesn't address if somebody still wants to live 3 or 4 people who have a problem and just live there. That doesn't solve that problem. And I'm concerned when I hear about control and accountability. Well, it should be about the health care of the patient. It shouldn't be about controlling what they do. If somebody chooses to live there, not be treated with some other individuals that have the problem, then that's their purview and they should be allowed. But the reason why I'm supporting it at this time is because we're going to be looking at it from this perspective.
Mr. Chair.
No.
Thank you, Mr. Chair. I just have a few questions, and I'm puzzled by the business license comments that the league made. I could understand if in different circumstances, but maybe we need a sober living facility, but 3 or 4 of my colleagues get together and we rent a house or we buy a house and we live there. I can understand that, but isn't somebody as a business providing this sober living facility in a community so that folks who are recovering can come there and live and recover after their treatment? Isn't it a business we're talking about? Somebody familiar with the process here, because maybe
Senator, that certainly can be one scenario. I think another scenario is what the chair pointed out, where individuals truly do come together, form a small family, if you will, of under 6, and share a house. They may have their own internal procedures and methodologies that they use to try to keep themselves substance-free and away from alcohol and drugs. I would also point out to the chair's comment that we actually do have a licensing authority within state law right now for recognized drug treatment programs. And they do have to be registered with DHCS, and they have to go through a process and follow it up. What we're talking about here, however, are units that are 6 or under that are not subject, are not necessarily trying to do drug treatment programs. And so that is who is being restricted potentially under this law, those folks that you identified, individuals who really would want to come together and be able to live in a house and decide their own protocols for determining that without being subject to the state licensing requirements.
So back to me. So some of them would be subject to the business license requirement.
If they're in a larger facility over 6, yes, absolutely, they would.
What about others? If it's a business, and most municipalities have a business license. I have a business license, and it's me, myself, and I in my house, because the city that I live in has a business license requirement if you're going to operate a business out of your home. So there would, in some cases, there would be a business license that would address some of the data that's required by this.
But I think Mr. Carrick was right in his comments earlier that the fair housing law actually does prohibit that when it comes to people residing together.
How can that be? What's the protected category?
If they're
disabled.
Oh, there's many protected categories. Disability would be one of them, and drug and alcohol is considered to be disability for the purposes
requirement? I don't buy that.
Well, I believe it's well accepted within the law.
Exempted from the business license requirement. So substance abuse facilities in the city of Riverside that operate as a business do not have to file a business license with the city of Riverside? Mr. Carrick?
I don't know if it's on. Senator, the chair mentioned the situation, and I think you touched on it as well, as, 3 or 4 individuals living in a house. They're not really connected to anything. They decide to live together as roommates. That's not the government's business. We completely agree with that. What you get into with this issue is there's all sorts of shades in terms of these operations that are between that instance and what qualifies for state licensing. If you go back and look at Senator Wiggins' bill, there were efforts to have a definition to separate the two, to have, what are these facilities? Some of them operating, I would agree, as businesses. They're getting referrals. They're operating in a certain way that ought to be subject to some kind of licensure. They're not. That's the gray area where locals have tried to regulate, and it's a very difficult area, and that's why you have a list of bills here. It's been very difficult because of some of the other issues and the legal issues.
But the locals can still regulate through ordinance health and safety issues. So noise and trash and unsanitary conditions can still be regulated by ordinance, right?
So long as those standards are applied to all people in the community.
Well, I understand where we're trying to. We're trying to go with this, but I'm just trying to establish what regulatory framework exists at the local level to address some of these issues. And then I guess for the league, are cities currently really equipped to assess in-home supervision requirements, discharge planning, which is what this bill also requires?
Well, perhaps not, Senator, given the different duties there. However, there's a vacuum here. I think that's the point of the bill. There's a vacuum here, and it's the point of all the bills in the analysis. This is an issue that hasn't been addressed. One of the opponents listed or mentioned that given different changes in federal law, there's going to be a lot more of these facilities. So why don't we figure out some way to make sure 2 things are happening. One, the people in the facilities are actually getting the treatment that they need in some organized way, whatever that is. And 2, that when they're in these neighborhoods, they're conducting themselves, whether they're a business or not a business, in a way that fits in better with the neighborhood and operates in a way that a good neighbor should. So that's the balance we're trying to find, and Senator Bates is trying to find a path.